Thank you, Kyle, and thanks to the Bar Association for inviting me to come and speak and for turning out in such large numbers. Last night, my daughter and I were talking about the fact that I was going to give this presentation, and she said, "Is it going to be interesting and have a lot of stories?" And I said, "No, I'm going to pick apart this really complicated statute." And she said, "Well, then I hope you have slides, because if you don't have any slides, everyone's going to think you sound like the grown-ups in the Snoopy cartoons who just say, wow, 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 wow." And so thanks to my daughter and my CJA Ike, we made slides this morning, and now there are slides. I know that you all have a handout that I think came with the Zoom link. Everything that is in the slides and everything that I'll talk about is also in the handout. So it's sometimes in different orders, but there shouldn't be really any need to write down notes if you hear something that you think is interesting, because it should all be in the handout. So I'm going to share the screen now with the first slide, I hope. Got it. All right. So the only story that you get is the brief story of why I asked the bar if I could give this presentation today. And the reason that I share this, it's really two little stories, is because I think it underscores the reason why the statute is important for lawyers to know. I had a couple of cases a couple of months ago, and they were fairly tightly in time with one another. The first one was essentially the facts were a 15-year-old who has week on, week off parenting time with his mom and his dad, came back to mom's house with what mom saw to be a almost all the way healed black eye. And she asked the son, "What happened to your eye?" And he said, "Dad hit me. I don't want to talk about it." The mom came in to file for a TPO, and she brought the 15-year-old into court. A week or two after that, another case came in, and this one involved the sexual abuse disclosure by a 10 or an 11-year-old and her even younger brother. And they had recently disclosed the sexual assault to mom, but there was definitely no argument that under the circumstances, they were under the stress or excitement that was caused by the event or condition, because the event that they were disclosing was very old. The mom filed for a motion to restrict, and she also reported the case to the police, who opened up an investigation that was still ongoing, both at the time of the original restrict and also at the follow-up hearing. And in that case, mom's counsel wanted for me to do an in-camera interview of the child. Both of those cases had a handful of things in common, and the primary one when I first saw them was that I did not want to interview either of these children. First of all, and you'll hear probably different judges say different things about their willingness to interview, and I am in no way trying to tell you that I will not interview children in camera. That is not my point of this at all. But in these particular situations, my concerns were that I'm not trained to talk to a young child about a sex abuse allegation especially. I'm concerned about re-traumatizing the child. In the case of the 15-year-old who walked into the courtroom, I'm concerned about putting him in the middle of difficult litigation involving his parents. And I'm concerned when there's an ongoing police investigation that I'm becoming a witness, and also that maybe I'm going to compromise the integrity of the investigation itself. But in both of these cases, it's a restrict or a TPO, which ultimately becomes the PPO and the follow-up restrict. And so we're talking about situations where an emergency decision needs to be made about safety, which means that there's not time for a CFI investigation, and the statements are not clearly admissible under any other hearsay exception. And so I asked my colleagues, do you all on the bench who have been here longer than I have see 1325-129, the child hearsay statute, being involved often in domestic relations cases? And they said no. And I said, do you think it would help if I talked to the bar about that statute and how it could be used? And we all agreed that it would be helpful. So I do want to also underscore that I'll talk in this presentation about some thoughts that I have about use and about what the reality of the statute is on the ground. And when I talk about those things, those are my opinions only. I don't purport to have those be the opinions of the entire bench. So with that introduction, the story leads really into my first slide. Look, it's already failing. There we go. So here are the factual questions that you as a practitioner who might be a proponent for a child hearsay statement should look at that might trigger your consideration of using the statute. I suggest that in most cases where the statute is the most helpful, all of these issues are going to be present. But if you don't have one of them, I'm not necessarily saying you couldn't use it, but most of the time all the factors are going to be present. Those are a contested issue of abuse or endangerment, the fact that the child is the only witness to the event or is a critical witness, and by that I mean there is no adult witness who could say the same thing that the child could. There isn't another applicable hearsay exception. There's not enough time or maybe not enough funds for a CFI or a PRE, and the child will not be interviewed by the judge in camera. And so if you look at those, I'm going to say that I think in the DR world, that perfectly describes a pretty large portion that we see of motions for restriction of parenting time and temporary protection order cases where children are the protected party. It perfectly describes those in a lot of cases, but it doesn't describe very much else. And so the first thing I think I want to have you take away is that you're not going to generally use the child hearsay statute in a motion to modify parenting time, something with the best interest standard, because it's really not going to meet these criteria. The other things that you might want to look at before you go to the child hearsay statute is that if you have another hearsay exception, you might consider using that because, as we'll talk about in a minute, the statute is fairly cumbersome to use. And so, for example, if you can lay a foundation for excited utterance and get the statements in that you need to have in, you will find that excited utterance is a much easier foundation to lay than the foundation for child hearsay. The other thing I want to make clear is that being really proficient with this statute is never going to replace the need for a CFI investigation or a PRE investigation in appropriate circumstances. And the reason for that is because the child hearsay statute is quite narrow. We're going to talk more about how the only kinds of statements that can be admitted under the statute are descriptions of the abuse episode itself. So it's not going to cover things that fall short of the abuse but are collateral to it. So a statement like, I'm afraid to go back to dad's house, or I don't want to do the parenting time, is not ever going to be covered under the child hearsay statute because it doesn't qualify. And so the statute itself is not especially broad. My next slide is what kinds of statements fall under the statute. If you have the handout that I gave you, I put the statute on the first page of the handout, and I'm basically going to work through the subsections 2, 3, and 4 on this slide. But a quick preface for all of the subsections is that, number one, the offense or the abuse that is alleged doesn't have to be formally charged as a criminal offense in order to be asserted as an act that is subject to 1325-129. So if the proponent of the statement feels that the statement describes child abuse, the person against whom it is sought does not have to be formally charged with child abuse in order to bring in the statutory language. And also in all of these cases, the sexual behavior and the child abuse, and less so the domestic violence, the child declarant can be a witness or a victim. And so, like in the case that I talked about that made me want to have this presentation, we had an alleged victim who was the little girl, and then we had an alleged brother, well, an actual brother, who allegedly also saw some of the abuse happen. And the statute specifically allows that the child who is a victim or the child who is a witness can both testify, or either one can. So now I'm going to go to subsection 2, which is, I think, really dense and pretty hard to read. And so my translation of subsection 2 is that subsection is talking about statements describing unlawful sexual behavior that are performed on or in the presence of the child declarant. So the child declarant, again, not necessarily being the victim, could be a witness, but performed on or in the presence of the child. The reference is to unlawful sexual behavior, and then the child hearsay statute has a reference to CRS 1622-1029. If you go to that section, you're going to find a laundry list of offenses of unlawful sexual behavior. I think there are 13 or more of them. They are most commonly in real practice probably going to be sexual assault offenses, unlawful sexual contact offenses, which, speaking really broadly and not especially precisely, differ from sexual assault only in that sexual assault generally has an element of sexual penetration, and unlawful sexual contact is the touching of private parts for the purpose of sexual gratification or abuse. And there's also indecent exposure. There are a number of other crimes that are listed in the 1622-102 that also qualify under the child hearsay statute, but I think that you're going to see those in practice far less than the three that I named: sexual assault, unlawful sexual contact, and possibly indecent exposure. So those full qualifying list, the full qualifying list is in Title 16, and the relevant definitions for some of the offense terms that are used in Title 16 are located in Title 18 at 18.3.410. And again, this is in the outline. I think it's on page 3 of the outline. The tricky part of using child hearsay in sexual offenses is that the age of the child that can qualify to have a child hearsay statute admitted into evidence hinges on the age of the child in the offense definition. And so if you go to that long list of offenses, you'll find that many of those offenses have different ages. There are some that are 14 and I think 15, and some that are 18. And so if you have a situation where a child is alleging something, you want to make sure that you look at what the allegation is, what crime would that form, and what is the age of the child who would be the victim or the witness, for the purpose of making sure that the age of the child whose statements you want to admit is falling under the statute, because the age is different in many of the different sexual offense statutes. The statute also says, and by the statute I mean the child hearsay statute, also says that if the underlying criminal statute is silent on the age of the child that it applies to, then the age of the child hearsay declarant is 15. I should say 15 or under. So the next subsection speaks about out-of-court statements about child abuse. And child abuse is defined in 18.6.401, which the child hearsay statute directs you to. But essentially, the definition from Title 18 of child abuse is the following. Child abuse means an act that causes an injury to the child's life or health. Those are pretty obvious. Those are like the black eye that the teenager had suffered, any other form of physical abuse. The statute also covers permitting a child to be unreasonably placed in a situation that poses a threat of injury to the child's life or health. So under that umbrella would come any statement about mom was driving drunk when I was in the car, or dad hit mom in front of the child, or one parent is under the influence during parenting time in such a way and with a child of such an age where that parent can't be a safe caregiver. And just as an aside, I'm throwing out terms mom and dad a number of times, and I recognize that I'm doing it kind of willy-nilly, and I want to be clear that I recognize that moms and dads are both the accused and also the accusers in all these situations. I don't mean any offense or any generalization of importance when I throw out one parent or other. So the third definition is a continued pattern of conduct that results in malnourishment, lack of proper medical care, cruel punishment, mistreatment, or an accumulation of injuries that ultimately result in the death or serious bodily injury to a child. And in the case of the child abuse statute, the definition of child is 16 years old for all of the acts of child abuse. So unlike the sexual abuse statute, where you really have to chase the underlying age of the child victim, you do not have to chase the age around. The age of the child is 16 for acts or for statements under this statute. I think some of the time it's useful to point out that different people might have different definitions of what constitutes child abuse. And even after you hear the definition in Title 18, there might still be reasonable minds could differ about what does it mean to permit a child to unreasonably be placed in a situation that poses a threat of injury. And I think the important thing to know there, if you are the proponent of a statement, is that if you have something that's kind of on the edge of whether it would be abuse or not, expect that your judicial officer might ask, why is that child abuse? Or how does it fit under a description of acts of child abuse? I can think of one scenario where I had a 1325 or 129 hearing where the statement that the lawyer wanted to get in was statements about a dad who was consistently waking up a 10-year-old in the middle of the night with concerns about the 10-year-old's health. And I think it's arguable, and the only thing that I could say is that the practitioners on both sides should be prepared to talk about, is that a statement of child abuse, or is that concerning behavior that falls short of child abuse? The last subsection is subsection 4, and that's a description of an act of domestic violence that happens in front of the child. Subsection 4 also contains a reference to Part 1 of Article 3 of Title 18. And when I looked that up, to my surprise, that's homicide and related offenses. So if you have a child who has witnessed a homicide or related offense, or has witnessed domestic violence and makes a statement about either of those things, then those would fall under subsection 4 of the statute. The child's age, qualifying age in that subsection 4 is age 13. So once you know that you have a child declarant who has made a statement that you think qualifies under the child abuse, sexual behavior, or domestic violence, the next thing that you have to do is meet the requirements for admission from the statute. I separated these into threshold requirements and then the admissibility inquiry. And the threshold requirements are, first, that the substance of the statement falls under the statute. That's what we just talked about. It has to be one of those 3 types of acts. The second is that the child's age meets the statutory requirements. We talked about that. And then the third is that the proponent of the statement has to give proper notice to the party opposing. Proper notice is not defined under the statute. I think the statute says reasonable notice, and reasonable notice is left up to the judge. This is the place where I will make a comment that I will tell you I'm speaking for myself only, but if I have a proponent of a child hearsay statement and I know it's coming, I'll give an order that defines what I think is reasonable notice. So if it is a 14-day out restrict hearing, I will just tell the proponent lawyer, if you're going to bring in statements under 1325, 129, you need to give notice to the other party within a week of today's date. And if I don't see that coming and I don't give you an explicit notice, then I think it's a fair assumption that notice means written notice prior to the hearing. And if you're the objecting party about saying that you believe that the notice that you got wasn't sufficient, it wasn't reasonable notice, I think that you should be prepared to describe the prejudice that you have from not having had the statement disclosed sooner. And you should also potentially expect that the remedy that the judge might offer you would be a continuance of that hearing with the first restrict to remain in place until the next hearing, with the essentially if the judge accepts that you needed more notice because you were prejudiced by not receiving notice. Lastly, the question of what has to go in the notice. The answer is the statute says the particulars of the statement, which I think the case law defines, and I certainly also define as, what was the statement that the child made? when did the child make the statement, and who was there when the statement was made. The party who is trying to move for the admission of the statement does not, as part of the notice requirement, have to doesn't have to lay a prima facie case for the elements of reliability or corroborative evidence, which are the ones we're going to talk about next. Notice is just what was said, when, and to whom. So the next part of the requirements for admission is in 1325-129 subsection 5. And 1325-129 section 5 is really the meat of the statute. The requirements say that in a pretrial hearing conducted outside of the presence of the jury, the court has to find that the time, content, and circumstances of the statement provide sufficient safeguards of reliability, and that the child either testifies at the proceedings or is unavailable as a witness, and there is corroborative evidence of the act that is the subject of the statement. So a word about the operation of subsection 5 is that when you read the statute, you can really tell that 1325-129 is sort of presuming that it's being used in a criminal case. It says on its face, though, in all of the other subsections 2, 3, and 4, that you can bring child hearsay into a criminal case, a dependency and neglect case, a delinquency case, or a civil proceeding. And so it unquestionably, the statute itself applies in more than just the criminal context, but many parts of it, like subsection 5, are written with an assumption that you're talking about a criminal proceeding where, number one, there's a jury in the first place, and number two, where there is a pretrial hearing for the consideration of admissibility of evidence, and then later a trial where there's the consideration of the actual substantive reliability or the real substantive question for the fact finder. And so it gets a little sticky in the DR proceeding, and here's another area where I will tell you what I have been doing, but I haven't talked with any of my colleagues about what they have or would do in the same situation. But what I have been doing is, because the judge is the fact finder in the whole proceeding, I essentially hold a single hearing, and I'm going to talk about it as if it's a motion to restrict, although it could be something else, most commonly a protection order hearing. But I'll hold a single hearing where, when I first hear the case of the party who is the moving party for the restrict, who will almost in all cases be also the moving party for the child hearsay statements, I'll have them present their entire case, and then I'll stop and I'll make the findings about the time, content, and circumstances providing sufficient safeguards. And also, if the child's not going to testify, I'll make the finding of corroborative evidence, and I'll say which statements I'm going to consider in the weighing of the ultimate question about whether or not to grant the restrict. In the event that I say that, I'll then offer the opposing party an opportunity to testify. If the opposing party wants to testify, then there's some more proceeding where there's an opposing case. But if the opposing party doesn't want to testify, then basically the admissibility hearing about the admissibility of the statements comes right before the ruling on the substance of the allegation. And I'll talk in a minute about the consideration that I give to statements for truth of the matter asserted after I've already admitted them. But essentially what I'm doing is a single hearing where, in the moving party's case in chief, I'm looking at the statutory requirements, then I'm giving the other party a chance to testify, and then I'm making the ultimate finding, which may or may not substantially rely on the hearsay statements that just came in. So sometimes it really becomes one hearing that's all mushed together, really. Another word that I want to say about that second prong is, if the child will not testify, there needs to be a finding of unavailability and corroborative evidence. In my own practice, I think that unavailability is met by the judge declining to interview the child and there not having been time for a CFI. And so when I know that child hearsay statements are coming to a hearing, I'll make an initial finding that the child is unavailable because I'm not willing to interview the child for the reasons that I will usually say, but often they're the ones that I detailed at the beginning of this talk. And then that necessarily means that there is going to need to be evidence of the corroborative evidence prong in addition to the time, content, and circumstances of the statement providing sufficient safeguards of reliability. So I think in the DR context, unlike the criminal context, you're almost always looking, if you're on either side of the statement, you're almost always looking at needing to show both parts of the statute. So here comes the detailed discussion about the time, content, and circumstances of the statement providing sufficient safeguards of reliability. If you are going to read just one or two cases on child hearsay, the ones that I would read would be the ones at the bottom, People versus District Court and People versus Bowers, because those two cases cite a long list of specific things that the trial court is supposed to consider when it makes the determination about time, content, and circumstances of the statement. I put just the sort of umbrella topics in these little bullet points here, and those are the circumstances that led to the disclosure. This means things like, did the child volunteer the information, or did the outcry witness? So when I say the outcry witness, I mean the adult who is going to testify to the thing that the child said. So did the child volunteer the information to the adult, or did the testifying outcry witness ask questions? If there were questions, were they open-ended questions or were they leading questions? Something like, also, what was the demeanor of the child when the child was disclosing? What feedback did the listener give to the child's first statements that led to the child, if he or she did, making more? How much time passed between the alleged act that the child is describing and the disclosure to the outcry witness? What was going on in the time between the alleged act and the disclosure? And by that I mean, was the child in a DR case happily going to the parenting time of the parent who is now alleged to be the abuser? Or was there some kind of resistance to parenting time? Or also questions of what was going on in the household immediately prior to the disclosure. Is this maybe a teenager who's in trouble for something, and when the teenager has the heat on him, turns around and makes a different disclosure that changes the subject? Those are all things that fall under the heading of what were the time, content, and circumstances of the statement, and the court can analyze whether those things make the statement more reliable or perhaps make them less reliable. The second bullet point is the specific wording of the statements. And this really most often comes to pass when you're talking about a young child who is alleging sexual abuse. And there's a lot of case law on this because frankly, most of the 1325 and 129 case law comes in under young children and criminal allegations of sexual abuse. But all of the case law sort of generally says that the court is to look at whether the language that the child uses in the disclosure is language that makes sense for a child of that age, or is it language that the court might believe meant that an adult was either fabricating the statement or fed it to the child. So that's what I mean when I say specific wording of the statements. The third bullet is the child's general character and external motivations. This would go to things like, obviously, is the child generally truthful? Or was there something going on that would give the child motivation to fabricate or exaggerate a statement at that given time? So like that example that I gave earlier about, did the child disclose the alleged abuse when the child was under the gun for something else and it was a distracting thing? And then the last one is the credibility of the witness that's testifying to the statement that the child made. And in DR proceedings, I think maybe more than any other, I think the court probably expects that the court's going to hear from an opposing party who maybe doesn't have a good parental relationship with the other party. And then the trial court has to really look at the credibility of both the child who is alleged to have made the disclosure and also the adult who is relaying the disclosure that the child made to the court. And I think what I wanted to underscore here is that the trial court is allowed to consider the credibility of both parties, the child and the witness who is relaying the child's statement to the court, in its consideration of time, content, and circumstances of the statement, providing sufficient safeguards of reliability. The second prong, which, like I said, is probably going to need to be met in all DR cases because the court is likely going to have declined to interview the child, which is how you got here in the first place, is corroborative evidence of the act, which is the subject of the statement. Again, a lot of the case law in this area is also born from criminal cases with sexual abuse allegations, and because of that, there are long lists in People versus Bowers and some of the other cases that talk about what is and isn't corroborating evidence. A lot of that kind of corroboration is stuff that's just not probably available in most DR cases. It's expert witnesses that testify, medical witnesses that have done examinations. And so those are going to be things where if you have them, certainly consider them. But I put the most common ones that I think probably arise in DR cases on this slide. Those are visible injury or medical evidence of an injury. So this is like the mom who sees the healing bruise, and that's why she asks the questions in the first place. The healing bruise is a corroboration of the child's statement, "Dad hit me." The second prong that I put is the statements of the opposing party who presumably would be the alleged abuser. And so by this I mean perhaps dad hears concerning statement from child about mom, dad calls mom, and then mom says the following things to dad. So mom's statements are corroborative evidence of what the child said. And the last one that comes up often, and I think attorneys don't always know to look for it, is the presence of behavioral changes in the child. So the case law says that behavioral changes observed by really anyone can be corroborative evidence. And so that would be things like the child is suddenly reluctant to go to parenting time with the other parent. Maybe the child won't sleep alone, the child's sleeping with lights on, the child seems anxious or depressed. Those behavioral changes combined with the child's statements, which if they are separately found to be reliable based on time, content, and circumstances, behavioral changes are sufficient corroborative evidence to meet the prong for admissibility under that part of the statute. The thing to know that is not corroborative evidence, according to the case law, is more than one statement or consistency of statements made by the child about the same event. So if the same child is saying to mom, teacher, counselor, principal, Aunt Veronica, that this abuse occurred and is saying it consistently over and over and over again, that is not corroborative evidence because that is still the statement of the same child. A statement of another child, so like in the example where there is brother who observes and sister who is alleged victim, brother's statements are corroborative of sisters and sisters are of brothers. But one child's multiple statements to multiple people are not corroborative evidence of the statements themselves. So after the court makes the findings under subsection 5 that some or all of the statements have qualified as being sufficiently reliable based on their time, content, and circumstances, and also having corroborative evidence if needed. The question then becomes, after those statements have come in, what does the court do with them when the court is the fact finder? And this is another area where we get into the fact that this statute, although it clearly applies outside of the criminal context, seems to be mostly written for the criminal context, because subsection 6 says that after the court decides to admit the statements, and I put the dots there because there is some information about jury instructions which you don't need in the DR context. But basically it is for the jury to determine the weight and credit to be given the statement. And in making the determination, the jury shall consider the age and maturity of the child, the nature of the statement, and the circumstances under which the statement was made, as well as any other relevant factor. And so in this situation, again, just speaking for myself, how I take subsection 6 is that after I have admitted the statements, I need, as the fact finder, to make a separate analysis of, did they barely get admitted? Did I barely, only by a hair, find that the time, content, and circumstances were reliable, or that the corroborative act existed? I think that that's what subsection 6 is trying to tell the fact finder, that even after the statement is admitted, there still needs to be an evaluation of what proper weight can be given to the statements in the light of all of the other evidence in the case. And so that's, I think, the importance of the bifurcated or non-bifurcated hearing. So when I go through in a hearing on a motion to restrict and proponent does their case in chief and I have the child's statements, if the opponent of the statements, so the person who is trying to not have the restriction put in place, trying to convince me that the abuse didn't happen, I will use subsection 6 to really carefully consider the hearsay statement of the child, if it's the only thing on the one side, versus the testimony on the other side, because admission isn't necessarily sufficient to carry the substance of the hearing. And I'll tell you that I've definitely, in at least one case, found that something does meet the requisite prongs for admission, but then I turned around and said that I still wasn't going to find it reliable enough to carry the entire restrict. And so then essentially there's admission, but on the application of what weight should it get, I actually found in favor of the opposing party on the ultimate issue. So that is the statute. And I think the time worked out fairly well to leave us time for questions. I'm gonna take the slide off and I'm gonna see if I can find the chat myself, or else Kyle maybe need you to help me with it.
No problem, I'm here if you need me. Otherwise, you should be able to see the chat. I think one question had come in earlier, but it sounds like you answered it during the event. So then we have
I tried to answer it.
Okay.
Yep.
And then I have a new one from Bruce Weiner, if you'd like me to read that, or are you seeing them?
I can see it. It says, what is the procedure for setting the required pretrial hearing under subsection 5? Does the court expect the proponent to email the CJA or file a written motion requesting the hearing? No. Most of the time what has happened in practice has been that so in both the restrict hearing and in the TPO that becomes the PPO, there's the initial hearing and then there's the follow-up hearing. And most of the time, if I see child hearsay coming at the initial hearing for the follow-up hearing, I'll address counsel directly if they're present for the initial grant of the restrict or the TPO, or if they're not present, I might issue an order that says, if child hearsay is going to be used in this situation, then the disclosure of the substance needs to be made by X date. And then when we return for the hearing, I'll conduct the hearing like I described, where I'm just going to hear the case in chief of the statement proponent, which will include the statements. And then after I've heard the statement in the case in chief of the statement proponent, I'll tell the parties whether or not I'm going to consider those statements, and if so, which of them am I going to consider? And then I'll offer the other party the chance to present a case, and then I'll make the ultimate finding, where ultimately I'll weigh the importance of the statements that I did admit to the actual substantive question. So if you don't get the order because the judge didn't anticipate that the child hearsay statement was coming, then you might reach out to the CJA and say, permission to file the child hearsay notice, please. And I think the CJA would regularly grant that. I hope I answered that question. Any other questions? Comments? All right. Thank you. I hope it was helpful, and I hope I didn't sound like a snoopy adult saying wah, 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 wah. Anything else, Kyle?
No, it looks like one just came in from Jean. Did you want to read that from the chat?
Sure. I turned off my chat. And so Jean says the admission of the statements may have a huge impact on how to present a case. In that case, would the court consider allowing a separate hearing on child hearsay alone? I haven't had that come up before. I think that it's fair to say that the court would consider it. I think that the difficulty is going to be that in most of the hearings that I've presumed that we're talking about, there is the statutory time limit that is there to protect the party opposing the motion. And so I think that the challenge would be how to bifurcate the hearing in the way that you're describing while also preserving the party who has at this point lost contact with the child or lost unsupervised parenting time with the child. I think the challenge would be on how to bifurcate the hearing while still giving effect to the timeline. If it's agreed between counsel, it would be easy. If it's not agreed between counsel, I think it's certainly something that the proponent should and could raise, but I wouldn't want to try to guess about what the court would do in any particular circumstance. Anything else? Well, thank you again.
Absolutely. And this is Kyle again. Thank you everyone for joining us. And I'll be sending out the CLE form shortly from my own email. So if you don't see that, just feel free to reach out to me, but that should be coming through in the next hour or so. And we'll be posting the recording of this on our YouTube channel. So anyone who came in just a little bit late, you can check in on the beginning once that's up on our YouTube channel by tomorrow. But thank you so much to Judge Salamone for presenting today.
Thank you.
Excellent. Thank you, everyone. Bye.